Hello and welcome to the podcast series, Creditors Corner Legal Talk, presented by Debnam Attorneys at Law, where we explore a range of legal topics impacting the financial services sector. Please be sure to hit subscribe so you never miss an episode. My name is Karen Lowe, and I'm an attorney in the firm's Creditors Rights Group, and today I'm joined by two of my partners on the Creditors Rights team, Jeff Rogers and John Sperati. As we emerge from the pandemic and business gets back to normal, we thought today would be a great time to talk about some of the big do's and don'ts for filing proofs of claim in bankruptcy. But before we begin, I want to note the information provided in this podcast does not and is not intended to constitute legal advice. Instead, any and all information shared is for general informational purposes only. Listeners should contact their attorney to obtain advice with respect to any particular legal matter. With that out of the way, let's turn our attention to this week's topic. So, John and Jeff, thanks for joining me today to talk about a topic that we've all been talking about internally that we think is going to be a major issue as this year progresses, proofs of claim in bankruptcy. Appreciate you guys joining us today. So let's talk about what proofs of claim are generally. Jeff, can you explain to our listeners generally what a proof of claim is?
Yeah, basically it's exactly what it sounds like. When somebody files bankruptcy and that person owes you money, you have to verify that he or she owes you money, and a proof of claim is the way that you do it. It's a document that you file with the bankruptcy court, or sometimes you file it directly with the bankruptcy trustee if there is one, and usually there is. And it sets forth what you're owed, why you're owed it, and what type of debt it is, secured, unsecured, etc. So if you want to get any money from a bankruptcy, you're going to have to usually file a proof of claim.
So are there any cases where proofs of claim are not required?
Well, typically the answer is no. But there are a couple of exceptions. Sometimes you'll find a debtor that files a Chapter 7, what's called a no asset bankruptcy case. And that is what it sounds like, that the trustee who is appointed to administer that Chapter 7 case determines that there are no assets to distribute to creditors. Since there are no assets to distribute to creditors, the court takes a position that there's no reason to file a proof of claim, since even if you filed the claim, you're not going to get anything anyway. Typically, when you get notice of the bankruptcy, there will be a statement on the bankruptcy notice that will tell you whether or not this is a no asset case and whether or not you need to file a proof of claim. The other time when you really don't have to file a claim is in a Chapter 11. If a debtor in a Chapter 11 schedules you as a creditor and they schedule you correctly, in other words, you agree with how you are being treated or how you are being scheduled as a creditor in that Chapter 11 bankruptcy, then you're not required to file a proof of claim. But say in a Chapter 11, you think you're owed $12,000 and they schedule you as a creditor for $8,000. If you don't file a proof of claim, then you're going to be treated as a creditor for $8,000. But those are really the only two times that you shouldn't file or don't need to file a proof of claim. But 95% of the time, you're going to need to file one.
So, John, I don't know about you, but in my Chapter 11 practice, I always file a proof of claim, even if we're properly scheduled, just because, frankly, there are so few cases where I have ever seen us be correctly scheduled. I just go ahead and file them as a matter of course. Do you do the same?
I do the same. I find that debtors' information sometimes is, or many times is unreliable, and I would prefer to have my correct information with ballots, documents supporting, and that type of thing already in front of the court.
Yeah, I mean, I think it's good to have that fallback position that if the creditor hasn't filed a proof of claim and the time for filing has expired and I'm in a Chapter 11, to have that fallback position, but I don't tend to rely on it. So, but there are times I think that a debtor files bankruptcy and you may not want to file a proof of claim. Jeff, are there any instances where you recommend that creditors don't file a proof of claim?
Well, not really. If a bankruptcy is filed, and if you are given the opportunity to file a proof of claim, like John just said, you probably ought to take that opportunity. If it's a no asset Chapter 7, then the court instructs you not to file a proof of claim. So that's a situation when you would not. And then we talked about the Chapter 11 being scheduled correctly by the debtor. The only other time, I mean, if you have a small amount, small debt, it's unsecured, the chances of you getting paid anything in that bankruptcy are slim to none, then you may just decide not to file one. And many times clients will call up and they will want to pay their attorney to file a proof of claim, and the attorney ought to look at it, determine whether or not that creditor may or may not see anything from that bankruptcy, and it may just make a determination and that there's just no reason to file a claim because there's not going to be any distribution on your debt.
So that leads me to kind of an interesting question, I think. Proofs of claim are really filed at the start of a case generally. So when a debtor files bankruptcy, John, what things do you recommend that your creditor clients be considering and reviewing when that bankruptcy is filed?
The first thing that I ask them to do is go ahead and pull your file. Let's start gathering our documents. Let's start gathering our proof so that it allows us two things. One, we can potentially shortcut any problems if we have an issue with a potential security interest, or we have an issue with the balance, or anything that might impact our claim. But it also gives us an opportunity, as Jeff was just talking, to evaluate, does it make business sense to pursue this claim? If you have a small claim and it's a Chapter 7 and it's more than likely going to be fully discharged, there's not a whole lot of value in filing a proof of claim, especially in a no asset case. So that allows us right off the bat to be cognizant of whether or not we're being cost effective to the client, and do we even want to pursue that? And the second thing I want my client to do is to go ahead and put together an accounting of what their debts are, the various charges, how can we support that? And so that we're going to have to give the bankruptcy court and the debtor notice of our accounting and how we came to that. So let's go ahead and get all that together and see if we can't head off any issues prior to filing. And the second thing I always ask my client, or if they want me to do it, I'm happy to do it for them, is read through the schedules. If you can get them off and determine what your treatment is going to be under this particular plan, or if you're even being recognized by the bankruptcy estate as having a potential claim. Because sometimes there are clues in there as to how a debtor is going to treat your claim, whether it's going to be secured, fully secured, or partially secured, or unsecured. And if there's collateral involved, if they intend to retain the collateral and how it is they're going to treat the debts under your particular agreement with them so that they can retain the collateral under the bankruptcy code.
Yeah, my ag finance practice, we run into instances where the farm has filed because it's a legal entity in and of itself, but our equipment may have been leased or purchased by the individual. And we looked at those cases to see if we have been scheduled as a creditor and who's seems to be exerting ownership over that equipment. And sometimes we'll file those proofs of claim for notice purposes only, just to go ahead and make sure everyone has all the information and it's clear as to who the real parties in interest are. Jeff, what on your end? Is there anything else you can think of that creditors should be considering? Like what with your foreclosure or mortgage clients, is there anything special they need to be considering with that?
Well, John's right. I mean, first you need to evaluate whether or not the claim needs to be filed. Secondly, in most individual bankruptcies, Chapter 13s, for instance, you're going to have to file a proof of claim if you have a lien on something. If you don't file that claim, you run the risk of not being paid in the bankruptcy, which could cost you a lot of money. So it depends, but most of the time I usually tell my clients, you need to be prepared to file a proof of claim.
So let's turn to some of our do's and don'ts, which is kind of our topic here, and kind of maybe some sage words of wisdom from our combined, I don't know, I think we're pushing almost 90 years of practice between the three of us.
Yeah, thank you, Karen.
We're not as young as we used to be. The first do is file it timely. John, sometimes, there's bar dates in these notices of bankruptcy that are sent out to creditors that say, for instance, we kind of talked about the no asset case. It's a no asset Chapter 7, and it says in big letters, do not file a proof of claim. That's pretty easy. And then for other bankruptcies, I notice to creditors says bankruptcy's been filed, do file a proof of claim and file it by X date. But occasionally things happen, and for various reasons, creditors either don't know about the case or just plain miss the bar date. Is that always fatal to their claims, John?
It is not always fatal to the claim. I think you hit on one of the primary things that creditors sometimes miss bar dates for. And referring back to what I said earlier, debtors are not always the most reliable information as to the amount of the debts and who they actually owe the debts to. So it is common that a debtor will fail to notice a creditor about the debt, and therefore you miss the date. And there are provisions in the bankruptcy code, which I'll get to in a second, that allow you to file a proof of claim after what we call the claims bar date, or the expiration of time to file a proof of claim. First of all, just so we know what we're talking about, in Section 509B9 of the Bankruptcy Code provides for the disallowance of untimely claims. So that's your starting point. So it is possible that you would have a disallowed claim. And what I advise clients to do in these instances are one of two things. One, just file the claim, even if it's late, and then let the court, the trustee, or the debtor then try to object to the claim. Many times, if it's something that was going to get paid and there's no real reason to fight, those things will sail through and they get included anyway. But in the second instance, what we look to do is under Bankruptcy Rule 9006, a court in its discretion can allow a late proof of claim to be filed. And you have to demonstrate what the court in the rule has said is excusable neglect. Now, there is no definition for excusable neglect. And it's obviously not, well, I knew about the claims bar date, I was just really busy. You can throw in a bunch of other extenuating factors and maybe that gets you closer, but it's going to be a process where the court looks at a multiple 4 factors about, one, was this really excusable neglect? And 2, is the debtor going to be prejudiced by allowing this late claim? And it's sort of a balancing act. And we could probably do a podcast on its own about the various cases and what they say, but it's not always going to be fatal. But it is something that we try to like to avoid, especially if it's a smaller claim that was probably not going to get paid a lot or a whole lot in. You get back into this cost-effective argument. Is it cost-effective to fight with the court and the trustee about allowing your claim when you may not get enough money to even cover the expenses? So that's something that we just need to look out for.
I think it's also important to point out that we're talking about monetary payment on that claim. Even if you don't file the proof of claim, what happens with your collateral, John, if you're a secured creditor?
still have your potential lien on that collateral unless there's been some sort of action to strip your lien or to sell it free and clear of liens. But then you're going to have to wait to the end of the bankruptcy to recover your potential collateral if they maintain their bankruptcy status.
I think something you said is really important. There are some times that the attorney's relationships come into play. I remember at Chapter 12, I was sitting in a plan meeting with the Chapter 12 trustee, and for some reason, my client hadn't filed one of their proofs of claim and filed all the others, and I hadn't caught it, and I hadn't gotten the case till luckily after the bar date, so it wasn't on me. But because of the relationship, the trustee wanted to go, and the debtor wanted to treat that claim in order to get the other claim. So I think sometimes just counsel's relationship with opposing counsel comes into play.
And I think you're very right about that, because most bankruptcy attorneys in North Carolina will tell you that we are a collegial bar, and there's only so many people in North Carolina that do what we do. And there's only so many people in North Carolina, especially Eastern North Carolina, that concentrate on agriculture related finance like our firm does. So we run into the same people over and over and over again, and then build those relationships, whether they be good or bad. And a lot of times it can be beneficial to you if your trustee and your debtors counsel know that they can believe what you say and that you're not trying to pull a fast one on them. Those relationships can help you sort of, for lack of a better term, grease the wheels.
So one of our big do's here is do attach the required documentation. And while I think that in some respects is fairly straightforward, you attach stuff supporting the debt and an accounting of the balance, it does deviate depending on the nature of the obligation. So let's kind of break that down a little bit, looking at some of our different practices, because while all three of us do bankruptcy, our client bases and the verticals we represent tend to be a little bit different. So Jeff, why don't you start us off and talk a little bit about what a creditor needs to attach to a proof of claim for a claim that's secured by real property. So a lender on, say, a house or a commercial building that has a deed of trust, what do they need to attach? Because they're very special.
Well, you're right, Karen. You're always going to have to attach to the proof of claim something that verifies your debt. If that is an unsecured claim, then it may be an invoice or a statement of account. Something that just verifies the amount that's due and verifies that you sold that person goods or provided services to that person and weren't paid. For secured claims, you have to attach the basis for that security interest. When it comes to mortgages on property that is owned by individuals, you certainly have to attach a copy of the note, the deed of trust. If there have been any modification agreements that have modified the original terms of the note, they should be attached. So that's kind of a given. I mean, the proof of claim again is to verify that one, you're owed money, and two, to prove why you're owed money. And the why is that you attach in a mortgage situation copy of the loan documents. But there are, if it's an individual that's in bankruptcy, then there are some additional requirements that you have to meet according to bankruptcy code. If the claim includes any pre-petition interest, fees, charges, late fees, any other charges, forced placed insurance, payment of taxes that the debtor didn't pay, then you're going to have to provide an itemization of those expenses for the court. If you claim a security interest, which in a mortgage you are, it has to include the amount that's in default as of the date of the proof of claim. The reason for that is because you really have two different claims. You have your ongoing monthly mortgage payment, which is going to usually be paid through the bankruptcy plan, but doesn't have to be. And then you're going to have a claim or receive a payment on the amount that was in arrears. And so you're going to have to verify to the court what that arrearage is and what it's made up of. If it is in a mortgage on the debtor's principal residence, and most of the time it is, doesn't have to be, but let's assume for a minute that it is. And in a Chapter 13, that's usually going to be the case. Then there's a particular form you have to attach to your proof of claim called the Form 410A, which is a pretty detailed form, and it sets forth everything. It has different parts to it, and part 2, for instance, is calculation of the total debt. Part 3 is a calculation of the arrearage and how that arrearage is calculated. Part 4 verifies what the monthly payment is and how that monthly payment is calculated. So does it include escrow for taxes and insurance? Does it include any type of private mortgage insurance or forced placed insurance? This form 410A, fairly detailed, but it needs to be filed if the mortgage that you hold is on the debtor's principal residence. So again, if you think about why you're filing the proof of claim, you're verifying the amount that is owed to you and the basis for the claim. Then you're going to have to attach your contracts, and you're going to have to attach, documents that verify how much is owed to you and why. And it used to not always be like that, Karen. And you guys know that, but as things got more complicated, the courts, instead of fighting over a lot of issues about debt and the balance of the debt, the court came up basically with a form that says, okay, you're going to have to establish your debt and your arrearage at the time the bankruptcy is filed. And you're going to have to establish for both of those balances, arrearage and mortgage and total debt, what it's made up of. And that's what this form does. So that form needs to be attached if it's on the principal residence, which most of the time is going to be in a Chapter 13. And you're going to have to verify fees, costs, all that, and itemize them so that the debtor, the trustee, can look at it to determine whether or not the debtor disagrees with that. And that can help the creditor too, because if you file this form and you put on there that you're owed $152,000, the debtor's not going to be able to come back later and say that that's not what's owed to you, because this mortgage form is filed with the court as part of the proof of claim, and the debtor has the opportunity to object to it. And if the debtor doesn't object to it, then the amounts that are on the proof of claim are deemed to be correct.
Well, Jeff, if I ever thought about doing stuff that involves real property, you have just completely discouraged me from doing so.
Yeah, sorry about that.
That's all right. No, that's good. Better know than not know. And I think that kind of, emphasizes the fact that, your house is most people's largest asset and the most important asset. And I think a lot of times what precipitates these bankruptcies. And so there's a lot more care and attention needed to how these claims are dealt with. And I think what you were talking about reflects that. John, you and I are fortunate, I think, after hearing what Jeff just explained, and that we mainly deal with equipment and cars, and thank God for that. So what information do you need to be concerned about when you're a secured creditor secured by equipment or a car or some other piece of collateral that's not real property?
That's a good question. specifically for states that have, well, let's back up for a second. Automobiles, boats, trailers, motorcycles, planes, anything of that nature that is subject to a registration process from a governmental authority, specifically here in North Carolina, either being the North Carolina DMV or the North Carolina Wildlife Resource Commission, they are going to have titles that are issued by that entity to prove ownership of whatever the thing is, whether it's a car or a boat. And the liens, the financing liens for the purchase of those items will actually be recorded on those titles. And that is the thing, in addition to what Jeff said, your accounting, your contract note, whatever your financing arrangement is, and the copy of the title are generally properly included in your proof of claims. That demonstrates your debt, the amount of the debt, and your security interest in whatever the thing is. That gets into a little hairy situation where you get into equipment. Some of it's not operated on the road and isn't. We'll talk about that later. But for the most part in North Carolina, those are going to be your attachments. Now, we have a specific issue that's come up in North Carolina and a bunch of other states that are now moving to what we call electronic titling, meaning a paper copy of the title is not actually issued, and it's basically electronically recorded. And most of the creditors will have access to a service that will be able to allow them to print what was known as a lien detail sheet, which details basically all the information on the title that the DMV stores. However, it does not have the notations on it as a typical title would have about it being the lien holder. So let's say ABC Credit Corporation financed the purchase of the car. If you looked at the paper title, it would have first lien holder, ABC Finance Corporation. When a paper title, or excuse me, a lien information sheet will tell you that, but it doesn't have it documented as the title. So that creates sort of an issue in proofs of claim in bankruptcy, because in North Carolina specifically, trustees have been objecting to secured claims when only the lien detail sheet is attached. I think it is, I don't know the exact word. We've gone to this electronic titling for a reason, and I think it is just arcane that we have to produce a paper copy, but that's the status of the law right now. So we have been forced to go ahead and get paper titles for vehicles or boats or whatever the thing is that didn't exist prior to bankruptcy. Otherwise, our claims, our proofs of claims, are subject to objection and potentially move from what would have been a secured claim to an unsecured claim because we can't demonstrate the validity of our security interest in the thing. So that's been pretty specific to North Carolina, but a lot of other states that have moved to electronic titling are having the same issues.
So how do you deal with that? Do you wait to get the paper title to file this proofs of claim?
We go ahead, as soon as the client contacts us, if they want us to file the proof of claim, or if they're going to file their own proof of claim, we tell them to go ahead and file, knowing that you're more than likely going to get an objection, and you will resolve the objection by providing the trustee or the objecting party with a copy of the paper title. Unfortunately, corporations, unlike persons, can't walk into the DMV and get an instant title. So we do have a couple of week backlog. So if we know we've got some time, we'll wait to get the paper copy. But if we know we're running close to our bar deadline, we will go ahead and file, knowing we're probably going to face an objection that we will resolve later.
So, John, Jeff was talking about the fact that with respect to his clients, the pre-petition and everything, all the pre-petition costs and expenses are part of, I think, the Form 410A. For your clients, and for my clients, what do you think the best practice is for itemizing those pre-petition expenses and such that you're going to include within your proof of claim?
I'm sorry, I didn't mean to interrupt you, but I was going to say I always tell my clients, and if I'm preparing the accounting, to specifically detail what the specific charge is for, the date that it was incurred, and why. And that allows the debtor and debtor's counsel and the trustee to determine the full amount of the claim and if the claim is proper.
Yeah, I do the same thing. I go ahead and put that itemization, say, see Exhibit A.
And that's also helpful in the event, many times, and specifically in 13s, where if the boat, the car, the motorcycle, whatever it was repossessed, and we've encouraged storage and towing fees that we're going to be expecting to be paid for either at the end of the claim, or if the debtor wants the vehicle back or the thing back, what they're going to have to pay to get the thing back.
No, I do the same thing.
As far as for your practice go, how do you handle proofs of claim for leased equipment?
It's leased equipment is kind of its own little animal, because the first question you have to ask, is that a secured claim or an unsecured claim? You really have to look at the nature of the lease. Is it a dollar buyout lease that's really a disguised sale, or is it a true lease? If it's a disguised sale, I treat it as a secured claim, and I would treat it like basically the same as I would treat a retail installment sales contract. But if it's a true lease, then it's actually, and it always feels weird, it's an unsecured claim, because there's no collateral securing the claim, because the creditor is the owner lessor of that equipment and maintains all rights to that equipment. And in most leases, bankruptcy is an event of default. So when I file those proofs of claim, I file them as unsecured. I list the nature of our interest as the owner lessor, and I include the full value of the lease within the proof of claim, the accelerated value. The one question I think creditors have to be looking at is, they have to be looking at first, is it a true lease or is it a disguised sale? Secondly, is there residual value that needs to be added on there? Because as long as the debtor is in possession of that equipment, then you'd be entitled to not only the lease payments plus the residual value, which is the value the equipment still has that it's supposed to have at the end of the lease, part of it. So that's kind of how I deal with those. It feels kind of weird. I always feel like it should be a secured claim, but it's technically not. So that's kind of how we do it.
Interesting. Leased equipment always presents a quandary. Jeff, on the real estate side, do you ever deal with leased real property or premises?
Well, sure. A debtor could file bankruptcy and their principal residence could be leased. In situations like that, yeah, if the debtor wants to continue to live there, they're going to have to make their lease payments. But if they were behind a couple of months on their lease payments when they filed bankruptcy, the landlord should file a proof of claim for the missed lease payments, particularly if perhaps the debtor didn't schedule that, didn't tell the court that they were behind on their rent payments. So, yeah, I mean, it applies to landlords as well. If the debtor is going to continue to live in that house, they're going to have to continue to make their rent payment, just like they would have to continue to make their mortgage payment if they own the house. And in both cases, you're going to have to, to verify what the lease payment is and how far it's in arrears, so that the debtor can catch those payments up, during the bankruptcy. Karen, we've talked a lot about the dues, and there are a lot of dues, but there are probably a few don'ts when you're filing a proof of claim. Do you have any of those don'ts you want to share with people?
So many. So little time. The big one is, don't include non-public personal information or information that's protected by HIPAA. So all filings with courts, including proofs of claim, have to be redacted to protect an individual's non-public personal information that can be used to steal their identity. And that includes their social security number. I include tax identification numbers, their birth date, the name of an individual other than the debtor who is known to be a minor, any financial account number, all of that should be redacted down to the last 4 digits so that it cannot be identified. Obviously, for birth dates, they should be just redacted down to the year of the individual's birth. And if the claims for medical services, this is a big one. All protected healthcare information's got to be redacted. I've seen a lot of issues with this where somebody files and goes, "Oh no," and then they had to go back and have the court seal it and go back and amend the proof of claim. I will tell you that the court's patience with these sort of errors is really running on thin ice. There was a huge case here in the Eastern District of North Carolina involving a well-known hospital system that had a significant number of claims they had filed that contained HIPAA information. And so that to me is really the biggest one that they need to consider.
And Karen, I was going to say, and I'm glad you pointed that out, because courts are very cognizant of that and of protected information, and they do not want to see that on your proof of claims.
Yeah, they don't. And it's funny, is I had a case where the debtor actually included some information, and then the creditor kind of exacerbated it by including that information in the proof of claim, and we were the ones that were under the gun. I mean, you get an adversary proceeding for that, you can get sanctions for that. All of that's in play. And so as soon as you realize that's been done, you need to consult an attorney and get it fixed immediately. The sooner
in other words, don't make it worse.
Yeah, don't make it worse. So I think that's really the big one, is understanding that you've got to go through every attachment to that proof of claim and make sure that that information has been scrubbed out.
Another one that I think that confuses a lot of people is whether or not you can file claims on time-barred debts. And by time-barred debts, we mean debts that you could not ordinarily collect on if the debtor was not in bankruptcy. What about time-barred debts?
Well, I think where that comes up really is in the consumer aspect of a consumer debt, which is a debt that's incurred for personal, family, or household use. And, the FDCPA precludes you from filing litigation on it. And look, we're not the only people that were confused about it. That went up to the U.S. Supreme Court. The 11th Circuit was a little confused about that a few years ago. And the U.S. Supreme Court in Midland versus Johnson held in 2017 that a proof of claim is not a filing that's protected by the FDCPA. And the filing of a proof of claim on time-barred debt does not violate the FDCPA. The good news for creditors is that the CFPB has reaffirmed that position in their debt collection rule at 1006.26b expressly. And so I think, there are still, that's not to guarantee that a court won't look at it that way, and somebody won't push on it. But even in North Carolina, under our state debt collection rule, they really kind of have taken proofs of claim out of play on that. So it's something to think about, but I would look at your jurisdictional requirements. But the U.S. Supreme Court and the CFPB does not consider that a violation of the FDCPA, the Fair Debt Collection Practices Act.
And so I guess if it's almost equivalent to filing the proof of claim is not trying to collect the debt, it's just verifying what the debt is. Is that what the courts have held?
Yeah, they've said that that's for informational purposes only. And so it's not, and it's not something that the creditor initiated. The debtor initiated the bankruptcy. And so the debtor has brought this into play by initiating the bankruptcy, and the proof of claim is for informational purposes. So, I think it's, but it's been an issue that's been highly contested. It went to 11th Circuit. There was a ton of cases out of Alabama and the bankruptcy court that then went to the U.S. District Court in the various districts in Alabama, and then went to the 11th Circuit.
And the debtor has the right to object to that claim if they feel like that claim should not be paid during the bankruptcy.
That's right. That's right. So, and that's really kind of how the court looked at it. So, well, guys, I appreciate everybody being here today. I think this has been a really good conversation. I know I've learned a good bit, and I hope that our listeners have too. Is there any other kind of key do's and don'ts that we've overlooked today that either of you want to add? John?
I think we've hit all the high notes, but there's always things that come up. So, our contact information is always on our website if somebody wants to address with us specifically.
Yeah, and I'm going to get that out in just a second. I think that's really good. Jeff, anything specific?
No, I mean, I think, assuming we have any listeners still listening at this point, I would just say that filing proof of claims is more complicated than it used to be. And so if you want to file your claims yourself, you certainly can do that. Just get comfortable with the requirements for filing those claims.
Thanks, Jeff and John, for joining me today. And I want to thank our audience for listening. If anyone has any questions, feel free to contact any of us. My email address is cnloe, CENLOE, at smithdebnamlaw.com. Jeff's is jrogers at smithdebnamlaw.com. And John's is jsperati, JSPERATI, at smithdebnamlaw.com. And if you want to contact us, please feel free to. And as Jeff said, our direct dials and our emails are also available on our website. If you've enjoyed this podcast, we have several other episodes, and I hope you'll check them out. And I want to remind you that if you've enjoyed this podcast as well, we welcome you to subscribe to our podcast and continue to follow us on our journey through the creditors' rights world and consumer financial services. Thanks, and have a great day.